The Senate Committee on Government Affairs will come to order. Mr. Secretary, please call the roll.
Senator Daly? Here. Senator Ellison? Here. Senator Krasner? Here. Senator Neal? Here. Senator Ornshall?
Here.
Senator Rogich? Here. Chair Flores.
Present. Please let the record reflect all members are present. We have a quorum. Good afternoon, everyone, to what seems amongst one of the final Senate Government Affairs meetings, although we all know that moving forward this week will very much be at the call of the chair. We don't know what will arrive and when, and at times we'll have to improvise. So just please know that we are not intentionally having meetings in any different order, dates, or times to make it difficult to access them. It's just that at this point, we all got to work together to get out of here by Monday of next week, hopefully. We do have two items on the agenda. We have Senate Bill 467 and Assembly Bill 64. We're going to take them out of order. We'll start off with Assembly Bill 64 and then get into Senate Bill 467, and then lastly, we'll do public comment. And as always, I want to remind everybody, please support opposition and neutral. If you could keep your testimony to 2 minutes. And should you have a longer testimony, you can always submit that in writing to the committee. And with that, we'll go ahead and open up the hearing on Assembly Bill 64. Welcome.
Good afternoon, Chair Flores and members of the Senate Committee on Government Affairs. For the record, my name is Mike Morton, and I serve as Special Assistant Attorney General to Attorney General Aaron Ford. Before you today is Assembly Bill 64 in its second reprint. I will start with a very brief overview of Nevada's open meeting law as it stands today before describing the revisions contained in the bill. Nevada's open meeting law, or the OML, was first passed in 1960 and is considered a sunshine law. Sunshine laws exist in many states and are laws requiring public disclosure of government agency meetings and records. In enacting the law, the Nevada Legislature declared that all public bodies exist to aid in the conduct of the people's business. And it is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. This intent is stated in NRS 241.010. When the Attorney General's office conducts trainings on this law to public bodies across the state, the office emphasizes the importance of this provision as it guides the interpretation of the law by both our office and by the courts. Nevada courts have stated that the OML was promulgated for the public's benefit and as such should be construed in favor of openness and transparency. The OML applies to meetings of Nevada's public bodies, both of which are terms defined in Chapter 241 of NRS. A public body is defined in NRS 241.015 and includes any administrative, advisory, executive, or legislative body of the state or local government consisting of two or more people, which expends, disperses, or is supported in whole or in part by tax revenue, or which makes collective decisions or recommendations to such a body and is created by the state constitution, a statute, regulation, city or county charter or ordinance, executive order, or form a resolution. Subcommittees of public bodies are also public bodies themselves. The legislature is exempt from the OML by NRS 241.016, although it often follows many of the same procedural standards, such as publishing agendas, allowing public comment, and facilitating public access to meetings. The OML also only applies to a meeting of a public body, which is defined in NRS 241.015 as a quorum of the body together with deliberation or action. A quorum is generally defined as a simple majority of the public body. Deliberation is to collectively weigh, examine, reflect, or discuss, while action is a majority vote. So, the OML does not prevent all private discussions by members of a public body, but only those that involve a quorum. The open meeting law imposes several requirements on public bodies, including the posting of a full agenda that clearly and completely describes all items to be discussed, to be posted no later than 9 a.m. on the third working day prior to the meeting. Meeting notices also must be posted on the state's notice website, at the public body's principal office, and the public body's website if it maintains one. The agenda outline requires public comment periods at the beginning and the end of every meeting or before action items. It further requires that all supporting material be made available to the public when it is provided to members of the public body. Public bodies are also required to keep minutes of their meetings that include the substance of discussions and actions. By design, exceptions to the open meeting law are few and narrow. Public bodies may hold closed sessions to consider the character, alleged misconduct, or professional competence of a person. They may also receive information from their attorney regarding potential or existing litigation involving a matter over which the public body has jurisdiction and to deliberate toward a decision outside of the agendized meeting. However, certain litigation decisions must be taken during an open meeting unless the public body has delegated that authority to its chair or chief executive. Additionally, emergency meetings are authorized by statute but may only be used to address truly unforeseen circumstances such as disasters or health and safety emergencies. Any action taken in violation of the OML is void, and the Office of the Attorney General has statutory enforcement power to investigate and prosecute violations of the OML. Additionally, any person denied a right conferred by Chapter 241 of NRS may sue to have an action declared void. The public does not have to rely solely on the Attorney General's office for enforcement. Criminal and civil penalties may also apply to members of a public body if they knowingly violate the OML. The Office of the Attorney General strives to assist members of the public and public bodies in understanding and complying with the OML. We provide training to public bodies across the state and offer training videos on our website that are available to the public. There is a Deputy Attorney General assigned to answer open meeting law questions every day. With that background, AB 64 makes the following proposed changes to the open meeting law. In Section 1, the bill changes the exception for attorney-client conferences with public bodies to include all legal advice and deliberations regarding that legal advice, not just advice regarding potential or existing litigation. It can be difficult at times to determine whether a topic a body is receiving advice on is potential litigation versus general legal advice. This change will allow the attorney-client exception to extend to all legal advice that would otherwise be protected by the attorney-client privilege if that client were not a public body. Sections 2 and 3 have been deleted by amendment. Section 4 clarifies the meaning of the physical location requirement for contested cases and regulation hearings. It clarifies that the requirement for virtual public comment options is limited to when there is no physical location for the meeting. Section 5 removes any special privilege for a public commenter to defame or slander another person. This does not impose any additional obligations or legal liability, but simply puts public commenters on the same legal footing regarding defamation as if they were to make those statements anywhere else. Finally, Section 6 clarifies that all provisions of the open meeting law do not apply to proceedings related to an investigation conducted to determine whether to proceed with disciplinary action against a licensee under Title 54 of NRS, which governs professional licenses in the state. The existing language makes it unclear whether the proceedings are entirely exempted from the open meeting law or just exempted from the agenda and notice requirements. The proceedings described in this provision occur prior to any due process protections attaching, as they are preliminary investigatory proceedings. Many boards created pursuant to Title 54 of NRS already have specific exceptions from the OML for their investigatory committees, but this provision covers those boards that do not have specific exemptions in their individual statutory chapters. And with that, Chair Flores, that completes our presentation of AB 64 in its second reprint, and I'm happy to answer any questions that the committee may have.
And thank you for walking us through that history. I think that's always a little helpful. With that, members, we'll open it for questions. We'll start off with Senator Daly.
Thank you, Mr. Chair. And so Section 1, Sub 4C regarding the legal advice, et cetera. So give me an explanation of what can be done now and what this would change. So if I heard your testimony right, they could only do this before on potential or existing litigation. So now they could do it for just about anything. I have some examples that I might be able to tell you after I hear your question and see how this works.
Mike Morton, Attorney General's Office, for the record. Senator Daly, yes, you are correct. So currently, under existing law, a public body can have a closed session not subject to the OML to discuss any litigation, potential or existing litigation. The provisions of Section 1 of AB 64 would apply to all legal advice, but just legal advice. So an example would be if a public body was discussing the provisions of contract negotiations with a vendor or for a piece of property, provided that those conversations were limited to only legal advice from the public body's counsel on that matter, those would be provided an exemption from the open meeting law.
Follow, please.
And I understand the attorney-client privilege and being able to get that advice from the counsel, not in an open meeting environment. But one situation that I recall that I had with Douglas County School District, where they had on their agenda to award a project, construction manager at risk, and they had 3 different venues all under one contract. And I walked through, gave them a 15-minute presentation and said, this is where you're violating the law here, and this is why you can't do this here, and this would not be in accordance with NRS if you go forward with this, 3 different places. And they went into a private session, came out and voted it out, and it didn't say another word about anything. I suppose they were in talking to their attorney about what. So how are you going to know that, provided such deliberation is limited to the legal advice? Because they went back and talked, and I know that's under the old language, about all of it. Well, is he right? Is his interpretation correct? And they deliberated about the issue on whether they should proceed, which they did not do at a public body, but according to this old language. So how's it going to be done now if this passes? And how are you going to know if they limit it to legal advice? Is that going to be based on what they come out and say when they're done? If they just move on to the next issue and vote it out and have no other discussions? How are we going to know?
Mike Morton with the Attorney General's Office, for the record. Senator Daly, so it is, one, it would be incumbent upon that public body's counsel to abide by the open meeting law as it exists when they're conducting that meeting and those deliberations. The Attorney General's Office takes open meeting law complaints all the time, almost every day, and we thoroughly, in our Open Government Division, thoroughly investigates all of those complaints. And our investigatory power of open meeting law violations would allow us to delve deeper into what might have happened in that closed session in order to determine whether or not a violation did occur.
Well, it's just going to be, no offense to my lawyer friends, we have to trust lawyers. The honesty of lawyers. I kid. So it is going to be kind of in that particular situation, if they went back to discuss to say, are we in compliance with this, are we in compliance with that, and they come out and they said, or they discussed just the legal issue and said, is this correct, or are we within our bounds, et cetera. The only way you're going to know if they discussed more than just the legal issue is going to be based on what the discussion is when they come out from that. So I'm just saying, you'd have to make the complaint based on the fact that negative evidence almost is, well, they didn't say anything more about any issue, much less the legal issue, and just moved off on the agenda, passed the motion is all they did. So is that going to be evidence or not?
Mike Morton, Attorney General's Office, for the record. Senator Daly, obviously every open meeting law complaint or alleged violation is very fact specific. I would contend that probably no 2 open meeting law complaints or alleged violations are the same. So everything would be based on the facts and circumstances of that specific meeting of that public body.
Next, we'll go to Senator Neal, please. Well, we can start off with Senator Krasner and then we'll move back.
Thank you, Chair. Thank you for your presentation. My question is in regard to Section 5, subsection 3. It actually encompasses Section 5, subsection 1, 2, and 3. So in Section 5, subsection 1, it kind of talks about how a statement made by a member of a public in a public body in the course of a public meeting is absolutely privileged and does not impose liability for defamation. But then in the new section, Section 5, subsection 3, it says, except as otherwise provided by law, nothing in this chapter should be construed to affect any civil cause of action for defamation, libel, slander, arising from defamatory statements made by a member of the public while he or she provides public comment at a public body. So right now, and I know some of these public meetings get heated, if a member of the public comes in and says, elected official, let's just say city council person, I think you're lying and you lied about X, Y, and Z before, that's privileged. With this new change here in Section 5, subsection 3, would that city council person or other elected official now be able to sue that member of the public for slander or defamation of character with this new section?
Mike Morton, Attorney General's Office, for the record. Senator Krasner. Again, similar to my last answer to Senator Daley, every single one of those instances is very fact-specific and not something a general rule can cover. What the new proposed subsection 3 does is to ensure that for the mere fact that a public comment period exists, it does not give any special status to that member of the public to say whatever they want. Everyone gives their public comment for their own reasons. They're always allowed to offer their opinion on any matter on an agenda. But what the Open Meeting Law Working Group wanted to ensure was that no sort of special status was conferred upon a member of the public for the mere fact that they were offering public comment. And so defamation, slander, and libel laws exist, and they have their own standards of evidence as they're laid out in NRS. And so for the mere fact of saying it for saying something during public comment does not absolutely absolve that person from libel and slander laws as they're currently written.
Senator Ellison.
Thank you, Mr. Chair. I put that law in many years ago, open meeting law at the beginning and the end. And the reason that was is people would wait all day trying to get a comment on there to get onto a previous agenda. And that's why we had to do that, is because when they get back towards the back, they just shut it off. The people wait all day. So that's why Carpenter come to me and we put that law into effect. But I do have some questions. The open meeting law, and that's what that is for, is open agenda at the beginning and the end, is to make a comment. If the board sees that it's fit, then they'll put it on the next previous agenda. So one of the questions I've got is, you cannot take anything that's not on the agenda and take it into a private hearing unless it's set on the agenda that way. Is that not correct?
Mike Morton, Attorney General's Office, for the record. Senator Ellison. So closed sessions, closed portions of a public meeting can happen, but yes, they would be agendized as such. A public body can go into closed session during an open public meeting, but those particular sessions are agendized.
And that's what I didn't understand that when you did your presentation. It sounded like you could just take anything off the agenda and go into a private session. And I don't think legally that could happen unless it's not agended that way. Okay, so that clarifies that. Thank you very, very much. And the reason we had so many changes in that law was because of issues that would come up on that agenda. So we had to make sure there was an area in there that says, wait, we're gonna have to stop, we're gonna agenda it, and then we'll come back and then go into private session. And that's the only way it seemed like that we could do that and keep that on the law and protect not only the public, but also the board that it was heading to. So thank you. That answers that question.
Senator Neal.
Thank you, Chair. So I just had a question on, I'm pulling it back up. It was the section for the legal advice. You were just having that conversation with Senator Daley. It's just the strikeout of the potential litigation. So if a person is in a public meeting, let's just use the example, it's a city council meeting, and a city council member is asking, do you believe that certain instances or issues that have been affected or created is going to create liability for the city? Would that question fall out of the public meeting, or could that actually be discussed? Because a potential litigation matter is not, it's not real yet. It's just a discussion. But if an attorney could see that, it's like, well, I'm giving somewhat legal advice by saying it could potentially happen. But most constituents want to come and they have questions on whether or not something is, creating a liability, a legal liability. And that's not necessarily legal advice. It just wants to know, will this turn into a lawsuit? And that's a legit question. Is that now excluded?
Mike Moran with the Attorney General's Office for the record. Senator Neal, I think the operative language in Section 1, subsection 4, paragraph C, that you're asking a question about, is that that legal advice has to be tied to deliberation by the public body. So if a member of the public body in your hypothetical is just asking a question, if we go down this road, could somebody sue, or could somebody bring action against our entity? That wouldn't necessarily be exempt from the open meeting law. It's legal advice towards deliberation, and deliberation is always agendized. And so while I try not to answer hypotheticals with a yes or no answer on the record, especially about the open meeting law, that specific one wouldn't necessarily be exempt from the open meeting law.
Senator Rogan.
Thank you, Chair. Could you, going back to Section 5, could you please explain what happens if a member of the public, during public comment, makes statements that are a targeted harassment, that singles out a group or a person on a panel or a council, et cetera, based on their ethnic and religious identity? So, for example, Jewish people. So you have someone sitting here giving public comment, but it is a targeted harassment. Does this bill prevent that, or if you can explain if that's covered under this? I know you discussed defamation, et cetera, but when it rises to targeted harassment, what would occur?
Mike Moore with the Attorney General's Office for the record. Senator Rogich, so under the existing open meeting law, outside of this bill, a public body always has the authority to limit or stop public comment when it arises to something that basically prevents the public body from conducting its business. in your specific hypothetical, the public body would rely on their specific counsel to determine that. And in the targeting of one specific member of a public body, it would be then incumbent upon that member of that public body, if they wanted to pursue like their own separate action or litigation on whatever might have been said, whether it rose to the level of defamation or slander or libel. But from the public body's point of view, under existing law, the public body has the right to limit or place time and manner restrictions on public comment, to ensure that something like that doesn't occur.
Members, any additional questions? Seeing none, thank you again for the presentation. Appreciate your time. I'm going to invite you to sit back, and we'll invite those wishing to testify in support of Assembly Bill 64. If you could please come forward, either in Carson City or Las Vegas. Seeing no one coming forward, we'll go to the phone lines for support testimony.
Chair, your public line is open and working, but you have no callers at this time.
I did want to make a point of clarification. There appears that we accidentally are listing the wrong number for today for folk to be able to connect via public comment. Just want to make it clear that if you want to join us for testimony, support, opposition, neutral, or public comment today, that you must call 669-900-6833. Once again, that's 669-900-6833, and we will give everybody a second in case they are hoping to be able to log in. As I believe the number that we traditionally use in our here for our committee is not working at this time. So once again, 669-900-6833. Before we go back to the phone lines, I'll invite anybody wishing to testify in opposition, either in Carson City or Las Vegas, to please come forward. Seeing no one coming forward, and we won't go to the phone lines yet, just to allow for folk to log in case they are trying to do so as we speak. We'll go to neutral testimony, either in Carson City or Las Vegas. And seeing none, now we'll go back to the phone lines. Those wishing to testify in support, if you could please log in now. Again, it's 669-900-6833. Do we have anybody wishing to join us over the phone?
Thank you, Chair. If you would like to testify in support of AB 64, please press *9 now to take your place in the queue. Again, if you would like to testify in support of AB 64, please press *9 now. Chair, your public line is open and working, but you have no callers wishing to testify in support at this time.
Thank you. We'll stay on the phone line, and we'll go to those wishing to testify in opposition to Assembly Bill 64.
If you would like to testify in opposition of AB 64, please press *9 now. Chair, you have no callers wishing to be in opposition at this time.
Thank you. Is there anybody wishing to join us over the phone in the neutral testimony?
If you would like to testify neutral on AB 64, please press *9 now. Chair, you have no callers neutral at this time.
Just our luck. On the day that we're discussing open meeting law, we got the wrong phone number. I'm sure we're going to get some emails about that. Any closing remarks you may have on Assembly Bill 64? Oh, we're good to go. Thank you again for being here. We'll go ahead and close out the hearing on Assembly Bill 64. And next, we'll open up the hearing on Senate Bill 467.
Good afternoon, Chair Flores, Vice Chair Orenshaw, and members of Senate Government Affairs. For the record, my name is Timothy Galuzzi, State Chief Information Officer, Office of the Chief Information Officer within the Office of the Governor. Today I'm not joined. Adam Miller, the Administrator of the OCDC, was going to join me, but unfortunately he had transportation issues and he was unable to join me today. I have the pleasure of introducing Senate Bill 467, which is the enabling legislation for a previously approved budgetary decision unit. This bill implements the transition of the Office of Cyber Defense Coordination from the Department of Public Safety to the Office of the Chief Information Officer, combining it with the Office of Information Security, creating the Office of Information Security and Cyber Defense. The vast majority of this language is a direct copy from the enabling legislation of the Office of Cyber Defense Coordination, as it currently exists in NRS 480 and has since its inception since 2017, with minor adjustments to fit within the organizational structure within the Office of the Chief Information Officer, and to combine it with the existing Office of Information Security, as it sits within NRS 242. Currently, OIS is focused inwardly towards the executive branch, supporting our agency's partners, providing enterprise services, where OCDC is externally focused, coordinating activities primarily with municipal entities, counties, and cities, but also with some internal mission. As you could probably imagine, this has historically caused confusion and overlaps. This legislation solves that and creates a cohesive cybersecurity unit to enhance collaboration and communication with the executive branch and externally, as cyber threats do not stop at our boundaries. I have discussed this bill with stakeholders from municipal entities and want to be very clear on the legislative record. There is no intent in Section 13, which is carryover enabling legislation from OCDC, to prescribe the investments that entities may make. The intent of this section is to publish a strategic plan that includes best practices, recommendations, and guidelines, not mandates. And so I'll do a very quick section by section. Sections 1, 15, and 16 handle the creation and public disclosure of cybersecurity incident response plans and reports. Sections 2, 3, 15 through 16, 26, and 27 moves the Office of Cyber Defense Coordination to the Office of the Chief Information Officer. Section 17 merges the Office of Cyber Defense Coordination with the Office of Information Security. Sections 18 and 31 are in regard to the leader of OIS-CD, or the Office of Information Security and Cyber Defense. Section 19 requires the CIO to adopt regulations in support of the policy of the OIS-CD. Section 35 repeals provisions of NRS regarding OCDC from NRS 480. Sections 23 through 25 makes conforming changes to support the repealing of those provisions. And so with that, if there's any questions from the chair or from the committee, I will stand ready to answer those for you.
And thank you for the presentation and walking us through the sections. Members, any questions? Senator Neal, please.
Thank you, Chair. Just on section 11, sub C, I know it says private entities to the extent practicable, but what private entities are you envisioning who would be a part of a strategic, I guess, planning when you have the public policy statement about, how information needs to be protected?
Thank you for the question, Senator. For the record, Timothy Galuzzi, State Chief Information Officer. I think what we're envisioning here is any potential public-private partnerships. When we look at private entities, for instance, we currently have a contract with a consulting vendor, and they provide cybersecurity consulting, infrastructure consulting, research and advisory services. This section would enable us to continue those activities to provide us best practices in regards to private entities when we're developing plans. And I believe this is also carryover language from 480 as well.
So it's just gonna be, you don't expect there to be a cost associated with that public-private partnership?
Thank you for the question, Senator. Once again, Timothy Galuzzi for the record. Not outside of current business practices. If we currently have investments in those types of contracts, those investments would be in our current operations. And other opportunities for those types of partnerships would be working with, let's say, gaming industry. If they have critical vectors or concerns with cyber threats, and they want to potentially be involved in kind of strategic planning conversations, stopping short of investment, I think we would be open to having conversations with them to at least have a strategic conversation about how we can grow cybersecurity maturity throughout the state. I think we can have those conversations and build up an atmosphere where we're all kind of looking out for each other between the public and private, because we all need to kind of work together. I think that's what this line would enable us to do. So we're not throwing up massive walls and preventing those conversations.
Senator Daly.
Thank you, Mr. Chair. My questions are in that same section about the public or private entity in the state, and then where you're going to establish partnership with private entities to the extent practical. Now, I understand where you would hire a vendor to provide, security services or software or hardware, and they have a maintenance agreement to continue with that. Is that what we're talking about? And I know you mentioned gaming on some of that stuff. I'm just trying to figure out how some of that coordinates.
Thank you for the question, Senator. Once again, Timothy Galuzzi for the record. There's also a lot of best practices in this space, in the cybersecurity space, in just the general IT space, that we invest in research and advisory services in order to stay abreast to those. And we bring in those services to ensure that our folks are trained up, and we're bringing those best practices into the state of Nevada. And so that's kind of what I was talking about specifically in that case. I think that there's also opportunities in which we can reach out to the private sector throughout the state of Nevada to figure out what they're doing, because they're obviously in some situations, in a lot of situations, a bit better resourced than we are when it comes to technology and the resources that they have available to them. And so we want to learn from them in any opportunity that we get. So I think with this provision right here in Section 11, 1 sub C, would allow us that opportunity to kind of bring them in and pick their brains. One example of where we do that is the Information Technology Advisory Board that's currently in existence within the Office of the Chief Information Officer right now. And we have community representatives. Some representatives are representing gaming right now and the hospitality industry. So that is an example of where we're bringing in folks from private sector to kind of show us where the best practices are, not only within cybersecurity, but technology in general.
And understood, and that's why I kind of asked the question to follow up on that. Because you mentioned public-private partnership, and I don't want to confuse terms or get too in the weeds on that, but generally, that means that there is a private partner who's willing to make an investment and that there's a return on the other end of that, but that means there has to be a revenue stream for you to then pay them to do that. For instance, if you're going to build the toll road build that Sparks was looking at in the public-private partnerships, if we don't have the money to build the toll road, we'll put up the $100 million to build the road, and then you're going to pay us back over the toll, and you're going to pay us back over 30 years for us to operate and maintain, et cetera. That would be, there has to be a revenue source for them to do that. You guys are not talking about that type of public-private partnership. If, and that, I just want to make sure we're using the terms correctly, and that I understand getting information on an advisory council on what the best practices are, but to my knowledge, there's no revenue source for a public-private partnership. No way to pay them back.
Thank you, Senator Timothy Galuzzi. For the record, I'm picking up what you're putting down. Yes, this provision is not alluding to that type of public-private partnership, where we do have some areas within Office of the Chief Information Officer at large that currently does have revenue contracts with non-governmental agencies, entities. This provision right here specifically does not discuss that.
Understood. So you're more talking about partnering with vendors, partnering with other people in the industry to develop best practices, and then we would implement that separately over whatever revenue stream you may have. But it's basically you're buying a service.
Timothy Galuzzi, for the record,
in
correct.
that relationship, yes. Okay.
Absolutely.
Members, any additional questions? Senator Ellison, please.
Just one simple one. I think you already answered it. It says, relating to the governor's administration, transferring the Nevada Office Cyber Defense Coordination to the Department of Public Safety. Isn't that within the same office?
Thank you for the question, Senator. So this bill is transitioning the Office of Cyber Defense Coordination from the Department of Public Safety to the Office of the Chief Information Officer, and then it is combining it with the Office of Information Security within the Office of the Chief Information Officer.
Yeah, I thought they were in there and they could just do that administratively instead of a bill. So thank you very much.
Unfortunately not.
I appreciate
Thank you.
that, yeah. Thank you. That's it.
Members, any additional questions? Seeing none, thank you again for the presentation. And at this time, I'd like to invite you to sit back, and we'll invite those wishing to testify in support of Senate Bill 467, either in Carson City or Las Vegas. If you could please come forward. Welcome.
Thank you, Chair. Good afternoon, Chair and members of the committee. For the record, Randy Robinson, Director of Government Affairs for the City of Las Vegas, here in support of this bill. We think it's a good move, not only from a sort of governance and maybe efficiency standpoint, but also from a cybersecurity threat, defensive posture standpoint. There are just so many threats that occur on a daily basis. And you think of Las Vegas, internationally iconic brand, let alone name of a city. And there are just hundreds of thousands of attacks per day globally. Folks just trying to get in somewhere. They don't care where, they don't care how, they just want to get in. And so for us, being able to coordinate not only locally with our partners and fellow jurisdictions in the South, but with the state overall. In a previous role, I was Government Affairs Director for a international telecom firm. So we were involved when OCD, Office of Cyber Defense Coordination, was first created back in 2015 with then Governor Sandoval. And we had those conversations that you've been having now about how we tap into the knowledge and expertise of the private sector to help protect us as a state overall. I could tell you lots of scary stories of what's happening out there, and the threat has just evolved since then and continues to evolve every day. So a strategy like this, where we all get on the same page together, is crucial to defend all of us. We were particularly concerned, as Mr. Galuzzi pointed out, with Section 13 2D. That is existing language that was heavily worked upon when it was first created back in 2015 with the OCDC. and it hasn't been an issue, but we wanted to make sure that what that says is that when the state makes recommendations for investments, that it is vendor neutral. We can't, there are instances where it makes sense to have a variety. We appreciate him putting on the record.
And thank you for joining us. Welcome.
Good afternoon, Chair Flores, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber. For the sake of brevity, we'll go ahead and echo the comments of my colleague, Mr. Robinson. We're in strong support of this bill and its efforts to modernize and streamline our cybersecurity response initiatives. Thank you so much.
And thank you for joining us. Anybody else wishing to come forward in support of Senate Bill 467? Seeing none, we'll go to the phone lines. Do we have anybody wishing to join us over the phone in support of Senate Bill 467?
Thank you, Chair. Your public line is open and working, but you have no callers at this time.
Thank you. At this time, I'd like to invite anybody wishing to testify in opposition to Senate Bill 467, either in Carson City or Las Vegas. Seeing none, we'll go to the phone lines. Opposition for Senate Bill 467.
Chair, you currently have no callers at this time.
And we'll stay on the phone line. Is there anybody wishing to now join us in the neutral position for Senate Bill 467?
Your public line is open and working, but you have no callers at this time.
And lastly, anybody in Carson City or Las Vegas wishing to testify in the neutral position? Seeing none coming forward, any closing remarks you may have? Sounds good. With that, we'll go ahead and close out the hearing on Senate Bill 467. Thank you again for the presentation. And lastly on the agenda is public comment. Anybody wishing to join us for public comment? Seeing none in Carson City or Las Vegas, we'll go back to the phone lines one more time. Public comment for Senate Bill 467.
Chair, your public line is open and working. You have no callers at this time.
Sounds good. Thank you. And with that, members, we will be at the call. We will close out for today, but we'll be at the call of the chair for Wednesday with the understanding that we may have to do some last minute things. And we appreciate everybody's flexibility. This meeting adjourned.